So very good evening all the participants. We have already covered the case laws as per new syllabus of Supreme Court. So now we will try to cover High Court and let us see how much we can cover today. So I have already shared this PPT with you and I would request Pradeep ji to please start from this High Court case laws. Pradeep ji.
Yes, sir. Good evening. So, Univalue Projects Private Limited versus the Union of India and others. The case of Univalue Projects Private Limited and Union of India, Calcutta High Court decided on August 18, 2020, addressed the legality of a directive issued by NCLT on May 12, 2020. This directive mandated that financial creditors must submit a record of default from an information utility as a prerequisite for filing application under Section 7 of the IBC. Key issues and findings. Jurisdictional overreach by NCLT. The High Court determined that the NCLT exceeded its jurisdiction by issuing the directive as it lacked the authority under Section 424 of the Companies Act 2013 to impose such a mandatory requirement. This action was deemed ultra vires the IBC 2016. Interpretation of Section 7 subsection 3A of IBC. The court emphasized that Section 7 subsection 3A allows financial creditors to provide either record of default from IU information utility or other evidence of default. The use of or indicates that submitting a record from an IU is not sole method to prove default. Retrospective application invalid. The NCLT's attempt to apply the directive retrospectively to pending cases was invalidated. The court held that the subordinate legislation cannot have retrospective effect unless explicitly authorized by the parent statute.
Yes, please. Please carry on.
Inherent powers of NCLT. The NCLT cannot use its inherent powers under Rule 11 of NCLT Rules 2016 to introduce procedural requirements that conflict with statutory provisions. Non-mandatory nature of Section 215 of IBC. The court clarified that Section 215, which pertains to the submission of financial information to an information utility is not mandatory for financial creditors. Conclusion. The Calcutta High Court struck down the NCLT's directive dated 12th May 2020, declaring it ultra vires the IBC 2016. The judgment reaffirmed that the financial creditors are not obligated to submit a record of default from an information when filing application under Section 7 of IBC. They may rely on alternative forms of evidence as specified in the code and its accompanying regulations. This decision has significant implication for insolvency proceedings, ensuring that procedural requirements do not override the substantial rights provided under the IBC.
So we have read this section. Just a minute. So what is the meaning? We have to do, for understanding this section, a combined reading of section 7, subsection 3. If we see section 7, subsection 3, it says the financial creditor shall. So, as soon as the word shall is used, the normal interpretation is that it is mandatory in nature. So it says the financial creditor shall, along with the application, furnish a record of the default recorded with the information utility or such other record or evidence of default as may be specified. So it says the Supreme Court took it in a way that it is mandatory to file the record of default with the information utility. So section 7, subsection 3. Next in line is section 215. Section 215 talks of the procedure for submission, etc. of financial information. So what it says? It says any person who intends to submit financial information to the information utility or access the information from the information utility shall pay such fees and submit information in such form and manner as may be specified by regulations. 2152. A financial creditor shall submit financial information. So here also the word shall is used. A financial creditor shall submit financial information and information relating to assets in relation to which any security interest is created, has been created in such form and manner as may be specified by regulations. And in section 215 subsection 3, the word may is used. An operational creditor may submit financial information to the information utility. So it gives an impression as if a financial creditor is obligated under section 2152 and an operational creditor is, it is the discretion for the operational creditor to submit financial information. So combined reading of section 7 subsection 3 and section 215 read with the regulations. So we will read the regulations also. Let us see the related CIRP regulation on this. So what is the related CIRP regulation on this? Regulation 2A. What regulation 2A says? Regulation 2A says, for the purposes of clause A of subsection 3 of section 7, the financial creditor may furnish any of the following record or evidence of default. Certified copy of entries. So I am reading from CIRP regulations. CIRP regulation number 2A. सुदर्शन जी प्लीज म्यूट कर लीजिए अपने को. So for the purpose of clause A of subsection 3 of section 7 of the code, the financial creditor may furnish any of the following record or evidence of default, namely certified copy of entries, an order of a court. And 2B talks of record of evidence of transaction debt and default by operational creditor. So by reading all these, the NCLT came to the conclusion that submission of record of default with the information utility is mandatory while filing application under section 7. But the High Court reversed the decision of NCLT and it says that it is not mandatory. There are other options also because the use of word or is there. So it says the use of or indicates that submitting a record from an information utility is not the sole method to prove the default. So for understanding this case law, what you will do? You will read section 7. Just a minute. आपको क्या क्या पढ़ना है इसके लिए? एक तो पढ़ना है सेक्शन 7. इसी में ऊपर ही लिख देता हूं. Let me write here itself. Section 7, subsection 3, section 215 and CIRP regulations. CIRP regulation number अभी पढ़ रहे थे हम लोग, क्या था रेगुलेशन नंबर 2, रेगुलेशन नंबर 2A. So side by side, whenever we are reading these case laws, we should try to write all these things also, that what are the sections covered, and we have to read the section also again to have a better understanding of these case laws. ठीक है जी. Now next, Univalue project. Next is Rajiv Chakravarti. Yes, please, Pradeep ji.
Yeah, Rajiv Chakravarti, resolution professional of EIEL versus Director of Enforcement Directorate. Parties involved: petitioner Rajiv Chakravarti, resolution professional of IRA Infra Engineering Limited. Respondent Director of Enforcement ED. List of dates.
Yes. So list
April
of dates
9.
we need not read. We can directly go to
Okay.
the issues. Yes.
Issues: interplay between IBC and PMLA.
Hmm.
whether moratorium under Section 14 of IBC prevents ED from attaching the properties of a corporate debtor under the PMLA.
Hmm.
Jurisdiction of NCLT, whether NCLT has jurisdiction to rule on the validity of attachment orders issued under PMLA. Impact of Section 32A of IBC, whether protection under Section 32A of IBC extends to attachments made by the enforcement directors under PMLA. Ratio, detailed reasoning and conclusion.
Actually,
Ratio.
on PMLA, there are basically two case laws. One is this Rajiv Chakravarti, another is Varsanna Ispat. And the findings of both the case laws are entirely different. So, this case law of Rajiv Chakravarti, it deals with the power of the enforcement directorate. So, whether they can attach the properties during CIRP, because Section 14 says that no recovery
No,
proceedings can be done,
no,
no attachment,
no pressure.
no civil criminal proceedings. So, whether proceedings under PMLA can continue. We have read another case law also of P. Mohan Raj. So, P. Mohan Raj says that criminal proceedings can continue against the directors, not against the company, but against the directors. So, this case law deals with this issue whether PMLA proceedings can continue despite moratorium. Yes, please. Ratio. Yes, Pradeep ji.
Ratio. Interplay between IBC and PMLA. The moratorium under Section 14 of IBC doesn't prevent the Enforcement Directorate from attaching properties of a corporate debtor under the PMLA, as the PMLA proceedings are distinct from the IBC and serve different legislative purpose. Jurisdiction of NCLT. The NCLT doesn't have jurisdiction to rule on the validity of attachment orders issued under the PMLA. The proper forum to challenge such orders is adjudicating authority under the PMLA. Impact of Section 32A of IBC. The protection under Section 32A of IBC, which provides immunity to the corporate debtor from the prosecution for prior offences once a resolution plan is approved, doesn't extend to the attachments made by the ED under PMLA. The legislative intent behind Section 32A was to facilitate the revival of CD by providing a clean slate for the new management, but doesn't interfere with the actions taken under the PMLA to deal with the proceeds of crime.
Hmm. So, Section 32A. If we read Section 32A, Section 32A talks of a specific situation where a complaint has been filed. Let me read from Section 32A. Section 32A says 32A 1B,
Ah,
a person with regard to whom the relevant investigating authority has, on the basis of material in its possession, reason to believe that he had abetted or conspired for the commission of the offence and has submitted or filed a report or complaint to the relevant statutory authority or court. So, Section 32A 1B talks of a specific situation where the investigating authority has, on the basis of material in its possession, reason to believe that he had abetted or conspired for the commission of the offence and has submitted or filed a report or complaint to the relevant statutory authority or court. So these PMLA proceedings, they are covered in 32A1B. Okay? Now, side by side, we should read the Varsanna Ispat case also. है ना? So this case law we have read. Now let us go to Varsanna Ispat. ये वर्सना इस्पात कौन सा है केस? उसका है क्या, एनसीएलटी का?
एनसीएलटी का सर।
जस्ट अ मिनट, मैं इंडेक्स पर चला जाता हूं, इंडेक्स से निकाल लेते हैं इसको। एनसीएलटी का है ये रहा, वर्सना इस्पात।
yeah.
तो व्हाट विल डू, ये यहां से हमने किया है वर्सना इस्पात। यस, सो प्लीज रीड दिस वर्सना इस्पात केस ऑल्सो साइड बाय साइड। तो दोनों केसेस
Okay.
आर सिमिलर इन नेचर। यस प्लीज।
So facts of the case: the Director of Enforcement
एक मिनट,
of
इसको ना ये
Central.
एनवायरनमेंट पता नहीं कैसे कर दिया, ये एनफोर्समेंट है, वो कई बार ऑटो करेक्ट कर देता है अपने आप ना। यस प्लीज।
attached some of the properties of Varsanna Ispat Limited,
Hmm.
the corporate debtor. The resolution professional filed an application before the adjudicating authority, Kolkata bench, for release the attachment of certain assets of the CD by Deputy Director of Enforcement. The attachment order was issued on 10th July 2017, prior to the order of declaration of moratorium in the case in hand. Therefore, an order releasing the order of attachment by the Director of Enforcement is not maintainable. Maintainable हो क्या है सर?
हाँ, वो थोड़ा सा उसमें वो कोई बात नहीं,
हाँ,
ये एक वर्ड जो है
maintainable.
ऐसे मेन टेबल हो गया, इसको मेंटेनेबल, मेंटेनेबल, अब ठीक हो गया।
The aforesaid order dated 12th July 2018 is under challenge in this appeal. Issue involved whether the order of attachment by the ED is maintainable, whether Section 14 of Code is applicable to criminal proceedings or any penal action taken pursuant to criminal proceedings or any act having essence of crime or crime proceeds, whether PMLA 2002 overrides IBC. Argument put forth. Section 14 of IBC has an overriding effect on the provisions of PMLA. Reference was made to Section 238 of the IBC. It was submitted that during the period of moratorium, the creditors and all authorities causing any disruption in the corporate insolvency process cannot be allowed to do so. The provisional order of attachment cannot be confirmed by the Director of Enforcement during the period of moratorium. Analysis and decision. In Varsana Ispat Limited versus Deputy Director of ED, the NCLAT ruled that Section 14 of IBC does not override the prevention of money laundering PMLA in case of money laundering. This means that the assets seized by the ED under PMLA, even during the moratorium period of IBC, cannot be released under Section 14. The NCLAT emphasized that the PMLA deals with the proceeds of crime and money laundering, making Section 14 of the IBC inapplicable to such cases.
हम्म।
The Prevention of Money Laundering Act 2002 relates to the proceeds of crime, and the offences relates to money laundering, resulting in confiscation of property derived from or involved in money laundering, and for matters connected therewith or incidental thereto. Thus, as the Prevention of Money Laundering Act 2002 or provisions therein relates to the proceeds of crime, we should hold that Section 14 of the IBC is not applicable to such proceeding. Insofar as the penalty is concerned, offense of money laundering is punishable with rigorous imprisonment, which is not less than 3 years and has nothing to do with the corporator. It will be applicable to the individual, which may include the ex-directors and shareholders of the corporator, and they cannot be given protection from the PMLA, and such individual cannot take any advantage of Section 14 of the IBC. This part, we find that the attachments were made by the Deputy Director of ED much prior cannot derive any advantage out of Section 14. As the Prevention of Money Laundering Act relates to the different field of penal action of proceeds of crime, it invokes simultaneously with IBC, having no overriding effect of one act over the other, including the IBC. The appeal is therefore dismissed.
So this was the case, NANCLAT. So it says that PMLA, whenever anyone is found guilty, so there is a provision for rigorous imprisonment, and imprisonment can be done to the individuals only. So section 14 will not be operative here. Yes. So Rajiv Chakravarti we have read, and Varsana Ispat also. Next, Venkata Sivakumar versus insolvency.
Yeah. So the case of CA Venkata Sivakumar versus insolvent IBBA was adjudicated by the Madras Court on November 3, 2020. The petitioner, a practicing chartered accountant and the IP, challenged the constitutional validity of Regulation 7A of Insolvency and Bankruptcy Board of India, Regulation 2016, and the bylaw 12A of IBBA, Model Bylaws and Governing Board of Insolvency Professional Agencies, Regulations 2016. Background: Regulation 7A, introduced by the IBBA, mandates that from 1st January 2020, an IP must obtain an authorization for assignments AFA from their respective IPA before undertaking any new assignments. Bylaw 12A outlines the criteria and procedure for obtaining an AFA. Petitioner's argument, the violation of fundamental rights. The petitioner contended that the AFA requirement infringes upon his rights under Article 14, 19(1)(g) and 21 of Constitution, arguing that it imposes unreasonable restrictions on his right to practice his profession. Excessive delegation. He argued that IBBI, as a delegate of legislative power, further delegated its authority to its IPAs without adequate safeguards, violating the principle of delegatus non potest delegere. Arbitrary criteria. The petitioner claimed that eligibility criteria for obtaining an AFA were vague and arbitrary, particularly the requirement to comply with unspecified circulars, directors, or guidelines. Court findings. Legislative competence. The court held that the IBBA had a statutory authority under sections 196, 207, 208, and 240 of IBC to frame the impugned regulations. Reasonableness of AFA requirement. The AFA mechanism was deemed a reasonable regulatory measure to ensure the integrity and professionalism of IPs, aligning with the objectives of the IBC. Validity of delegation. The court found that the delegation of certain functions to the IPA was within the permissible limits and did not constitute excessive delegation. Clarity of criteria. The eligibility conditions for obtaining an AFA were considered clear and appropriate, serving the purpose of maintaining high professional standards. Appeal mechanism. While upholding the validity of 7-day appeal period, the court suggested that the IBBA consider amending the regulation to allow for longer appeal window or provision to condone delays, enhancing the fairness in the process. As of now, the period is 15 days with effect from 27th April 2021. Conclusion. The Madras High Court dismissed the writ petition, affirming the constitutional validity of Regulation 7A and the Bylaw 12A. The decision underscores the court's recognition of IBBA's role in regulating the insolvency professional and ensuring that the IPs adhere to the standard that uphold the objective of IBC.
Yes. So, by virtue of section 196, 207, 208 and 240. So if we read section 196, what section 196 says? Section 196 says that what are the powers of the board? So it says the board shall, subject to the general direction of the central government, perform all or any of the following functions. So board has got the power. So if we read section 207, so 207 talks of registration of insolvency professionals. 208 talks of functions and obligations of insolvency professionals. And 240, if we read, so section 240 talks of the power to make regulations. So all these read together, they allow the board to frame regulations. And board can delegate its authority to the IPA also. So this regulation 7A and model bylaws 12A, which was challenged, so it was found to be in order by the High Court. Yes, please. Next. Next is also by the same person, CA Venkata Sivakumar. Yes, please.
Parties involved: CA Venkata Sivakumar, respondents, IBBI, represented by its Deputy General Manager, IPA, ICAI, represented by CEO, the Union of India, Ministry of Corporate Affairs, Union of India, Ministry of Finance. List
Yes.
of dates. Sections, rules, regulation refer to the sections of
Sections are
IBC.
same. Sections are same
Okay,
as
sir.
in the previous case. So here also,
Regulations.
besides section 7A and 12A, there were two other regulations also which were challenged. So as you know that as per these regulations, the insolvency professionals, they are required to pay a certain percentage of fees
Yes, sir.
of the professional fees earned in the preceding financial year. So the point here is whether the board can levy any such fees. So regulation 72CA. So let us read this regulation 72CA. What this says. This is insolvency professional regulations. Now it is this fees is 1%. Earlier at that point when this was raised,
0.25.
so it was 0.25%. Now it is 1%. And
1%.
let us see this regulation 13 also. So regulation 13 to CA. So if we read 13 to CA, so it says 1%. So both these fees are now, as of now, they are 1%. So the challenge was whether any such fees can be levied based on the turnover. This was the main issue. And what was the ratio and decision? Let us see. You can read directly from this ratio.
Ratio.
Hmm.
Detailed reasoning and conclusion. Regulation 72CA payment of fee calculated at 0.25% of the professional fee earned in the preceding financial year. Ratio constitutional validity of Regulation 72CA. Regulation 72CA of IBBI Regulation 2016, which requires insolvency professional to pay a fee calculated at 0.25% of professional fee earned in the preceding financial year, is constitutionally valid. It falls within the powers conferred upon the IBBA by Section 196 by Sections 196, 207, 208, and 240 of the IBC. The regulations ensure that the insolvency professionals contribute to the regulatory framework that maintain high standards and accountability. Requirement of fee payment. The requirement for insolvency professional to pay this fee is reasonable and justified. It ensures that the regulatory body can effectively oversee and maintain the integrity of the insolvency process. Delegation of power. There is no excessive delegation of power in framing Regulation 72 CA. The IBBA has appropriately exercised its regulatory powers to impose this fee, ensuring the proper functioning and accountability of insolvency professionals within statutory framework of the IBC.
So this was the case.
Conclusion.
Hmm.
Regulations are constitutionally valid. The court concluded that Regulation 72CA and Regulation 132CA of IBBA Regulation 2016 are constitutionally valid. The regulations are within the power conferred upon the IBBA by the IBC and intended to maintain high standards among insolvency professionals and entities. Requirement of fee payment is reasonable and justified. The court held that the requirement for insolvency professional and its IPEs to pay a fee based on their professional fee earned and turnover respectively is reasonable, justified, and in line with the regulatory framework. The criteria for the payment are not arbitrary or unreasonable, ensuring the competence and accountability of insolvency professionals and entities. Delegation of power is appropriate. The court found that there is no excessive delegation of power in framing the Regulation 72CA and Regulation 132CA. The IBB has appropriately exercised its regulatory powers to ensure the proper functioning and accountability of insolvency professionals and the entities. Petition dismissed. The court had dismissed the writ petition, holding the validity of impugned regulations. The petitioner was advised to pursue the pending appeal regarding the rejection of his AFA application or to submit a fresh application after remedying the stated defect.
Hmm. So this was the
I,
case law. So now,
One more case is there, sir.
eh,
One more case is there related to this one only.
there are two
I think
cases only.
One more is there, sir.
sir,
Only
last
one we
line,
have
I
already
think
read.
is
No, sir. Total three, I think.
You think or
After that,
you no?
yeah,
Please
yesterday.
सिलेबस में देख लीजिए एक बारी.
ठीक है सर, मैं देखता हूँ. इसके बाद after one case, one more is there, I think. Total three case. That means same related case only.
ओके, अभी देख लेते हैं. जस्ट अ मिनट. So we can raise 1% now. ये हो गया।
तारकन के बाद टाटा स्टील के बाद देख लेते हैं। टाटा स्टील बीएसएल लिमिटेड के बाद
हाँ
वी
हाँ,
वेंकट शिव कुमार वर्सेस आईबीबीए।
अभी देख लेते हैं, अभी देख लेते हैं,
8 नंबर।
अभी देख लेते हैं। हाँ, ठीक है, राइट, 6। हाँ, तो एक बार इसको भी पढ़ लेते हैं। यस प्लीज, प्लीज प्रदीप जी, read this case law also. So there are three case laws by CA V Venkata Shivakumar. Yes please.
Yeah, IBC. Mere conferment of authority on IBBA and insolvency professional agency for supervision, control, and disciplinary proceedings under Section 204 by itself cannot be upheld to be conferring of excessive or unbridled power. Section 204 being only an enabling provision for which appellate remedies are available. There is no constitutional infirmity in any of the provisions under Section 204. IBC, where disciplinary proceedings were initiated by IBBA against the petitioner or member of IBBA and petitioner challenged the constitutional validity of Regulation 23A of IBBA, model bylaws, and the governing board of insolvency professional agencies, Regulation 2016. Petitioner or any other aggrieved professional could only insist upon prompt completion of such proceedings, and hardship during proceedings could not be a ground for challenging the regulation itself, and therefore constitutional validity of Regulation 23A was to be upheld. Case summary. Whether Section 204 of IBC, Regulation 23 of IBBA model bylaws governing a Board of Insolvency Professional Agencies, Regulation 2016 are constitutionally valid, particularly whether they confer excessive powers on IBBA and a professional agencies and violate fundamental rights under Article 14, 19, 21 of the Constitution. The petitioner, a chartered accountant, member of IPPA, was appointed as a liquidator. His application for authorization was rejected by the Indian Institute of Insolvency Professionals of ICAI. Two disciplinary proceedings were initiated against him, one by IIPA and other by IBBA, for allegedly sharing confidential liquidation information. Okay. So facts. The petitioner was a practicing chartered accountant and member of Institute of Chartered Accountants of India, as well as a member with IBBA. The petitioner was appointed as a liquidator in a liquidation process. Since the Regulation 7 of IBBA Insolvency Professional Regulation 2016 required the insolvency professional to obtain authorization for assignment from the insolvency professional agencies, the petitioner made an application to the Indian Institute of Insolvency Professional of ICAI, but the said application was rejected. The petitioner filed a writ petition challenging the constitutional validity of 7A of IBBA Regulations 2016, but the same was dismissed. The complaint was filed by a member of the NCLT against the petitioner before IBBA, and another complaint was filed before the IIPA as the petitioner shared the confidential information relating the liquidation process to their respective scheme proponents. A show cause notice was issued by the IBBA calling upon the petitioner to show cause as to why suitable disciplinary action could not be taken against him for contravention of Section 2082A and 2082E. Regulation
So for
23A.
understanding this case law, we have to read section 204, which talks of functions of the insolvency professional agency, which allow the insolvency professional agency to suspend or cancel the membership of the insolvency professionals. They can also monitor the performance of its members. And Regulation 23A of Model Bylaws, it says that the authorization for assignment shall stand suspended upon initiation of disciplinary proceedings by the agency or by the board. So Regulation 23A of Model Bylaws and Section 204, we have to read before understanding the implications. Yes, please.
Regulation 23A, IBBA Regulation 2016 lays down that the said assignments shall remain suspended once the disciplinary proceedings are initiated. As a matter of fact, Regulation 12A of IBBA Regulation 2016 categorically provides that the RP should not have any disciplinary proceedings pending against them. If that be the case, it is only logical that there is an ad interim suspension of the assignment if any disciplinary proceedings are initiated subsequently also. The power
Hmm.
of ad interim suspension of the assignment if any disciplinary proceedings are initiated subsequently also. The power
Hmm.
of ad interim suspension has always been held to be valid and natural exercise of power. And the only requirement there must be an express rule enabling the same. There is no discretion vested with IIPI and the suspension is automatic. Once the disciplinary proceedings are initiated, therefore, it can neither be termed as manifestly arbitrary nor be challenged on the ground of any confirmation of the unguided, unbridled power. The power of suspension is not a punishment and it is an ad interim measure. And if one has to be issued with show cause notice, then very purpose of an ad interim suspension is lost in as such as ultimate punishment with imposed only on the conclusion of disciplinary proceedings, it cannot be said that any substantial or vested right of the RP is violated. On the contrary, the purpose of suspension is to immediately keep the erring person away from the office so that the relevant materials and evidences which are on record be properly collected and that there is an impartial and fair inquiry in the issue. Therefore, the requirement of issuance of show cause notice cannot be read into a provision of ad interim suspension. Only to avoid hardships, normal, swift, and prompt completion of process of disciplinary proceedings is insisted upon. Therefore, the petitioner or any other aggrieved professional can only insist upon prompt completion of the proceedings, and the hardship cannot be a ground for challenging the very regulation itself.
Yes. Please read.
Regulation 23A. The court held that automatic suspension of AFA is valid and not a punishment. It is an ad interim measure to ensure impartiality during the disciplinary proceedings. No discretion is exercised in suspension. It is automatic and not arbitrary. While it may cause hardship, this is not the grounds for invalidating the regulation. Section 204 of IPC. The section merely enables professional agencies to regulate and discipline insolvency professionals. This doesn't amount to unbridled or excessive delegation. Dual control by IBBA and IPA is not unconstitutional and serves regulatory effectiveness as recommended in the Bankruptcy Law Reform Committee report. There is no violation of Article 22 double GOPD as a punishment for the same charge by both authorities didn't occur. IBBA dropped its case after IAPA concluded its proceedings. Res judicata applies. The court held that the petitioner had already challenged related regulations earlier, and these petitions were barred by the constructive res judicata judgment. The red petitions were dismissed. The court upheld the constitutional value of Section 204 and Regulation 23A, reaffirming that the regulatory oversight and at interim disciplinary measures are reasonable, necessary, and legally sound.
Actually, the case law was based on the premise that why you are automatically suspending the AFA once a show cause notice is issued. The actually, first of all, inspection or investigation take place, and only when there is a preliminary finding that okay, there exists a case, only then show cause notice is issued. So even prior to issue of show cause notice, inspection or investigation has already taken place. So, and it says that AFA shall stand suspended as soon as the show cause notice is issued. Because show cause notice is the start of the disciplinary proceedings. But please appreciate that even before disciplinary proceedings are started even before a show cause notice is issued under section 220. There is already an inspection or investigation which has established the case prima facie. Yes. Case number 5. Yes, please.
Tata Steel BSL Limited versus Venus Recruiter Private Limited. The phrase arising out of or in relation to as situated under section 65C is of a wide import, and it is only appropriate that avoidance applications are heard and adjudicated by adjudicating authority, that is NCLT or NCLAT, as the case may be. Notwithstanding that the CRP has concluded and the resolution applicant has stepped into the shoes of promoters of erstwhile corporate debtor.
So
Case summary issue can
the question here was that once CIRP stands completed, whether RP still has a role or RP has no role and only resolution applicant will do. This was the case. So basically in this case the issue was, can avoidance applications be adjudicated after the approval of a resolution plan? Because if we read section 26, if I remember correctly, so section 26 says that PUFE proceedings can continue.
Yeah, it shall not affect the proceedings
है
of
ना?
corporate insolvency.
Yes. So
Yes,
section
yes.
26 clearly says so. So now the question here is, once CIRP is complete, then who can take up this application? Whether RP can or cannot. So once CIRP is complete, resolution plan is approved. So whether the RP will follow up or the new promoter will follow up, this is the case. Yes, please. Conclusion.
Regulations are constitutionally valid. The
नहीं
court
ये
concluded that
वाला
the
नहीं है, ये तो
yeah,
लगता है इसमें
हाँ
गलत आ
हाँ
गया.
yeah,
ये
okay sir.
अच्छा ये दोबारा आ गया है. ठीक.
Facts.
Yes.
Facts. The NCLT, by
हाँ.
an order, initiated CRP against the corporate debtor, and the resolution
हम्म.
professional was appointed.
हम्म.
Therefore, a public announcement was made inviting submission of claims by prospective resolution applicant, and the COC was constituted. COC approved resolution plan proposed by the appellant SRA, and RP filed an application before the NCLT seeking approval of said resolution plan. During the period of pendency of approval of application, the RP discovered several suspected transactions entered into by corporate debtor with related parties, including preferential transaction undertaken by the corporate debtor with respondent. Consequently, prior to the final approval of resolution plan, the RP has filed an application before NCLT under Section 25(2)(j), Section 43 to 51 and 66 awareness application, wherein various transactions were enumerated as a suspected transaction with related parties. Held alternate efficacious remedy before NCLAT. It is apt to consider the preliminary issue regarding the maintainability of red petition preferred before the single jet. The single jets ruled that an alternate efficacious remedy did
Efficacious
not
remedy.
exist in the efficacious remedy did not exist in the instant case, since the proceedings pertaining to the avoidance application were not in relation to the insolvency resolution of the corporate debtor. The import given to the phrase in relation to the insolvency resolution has been narrowed down by the single judge to mean that the applications petitions must only pertain to the CARP, and after conclusion of CARP, no issues survives for consideration of the NCLT, making NCLT functus officio in respect to any application or petition with respect to the erstwhile corporate debtor. Key findings: avoidance application survive CARP. The High Court held that the avoidance application are independent of CARP and can continue post resolution. Their purpose is to benefit the creditors by recovering assets lost to suspect transactions, not to the benefit of new management. RP can pursue the applications post CARP. The RP is functus officio only with respect to the CARP, not for avoidable transactions applications. Filing the application before approval of the plan satisfies the RP's statutory duty under Section 25(2)(j). Timeline under Regulation 35 is directory. The regulatory deadlines for filing avoidance application is not mandatory. Delay in discovering or adjudicating transactions should not invalidate the application. Resolution applicant cannot reap benefits. Benefits from avoidance application adjudication must go to the creditors, not to the resolution applicant. Resolution applicant bid with commercial expectation and cannot claim unexpected windfall from subsequent recoveries. Judgment. The court set aside the earlier discussion of single judge that avoidance application become void after CIRP. It directed the NCLT to proceed with hearing of the avoidance application. Conclusion. The judgment affirms that the avoidance proceedings are integral to the IBC, can be adjudicated after resolution, ensuring that creditors are not denied recovery due to the procedural timelines or resolution
So
status.
this was the case. So the case here was that avoidance applications are a separate proceeding. So they can continue even post CIRP also. And the role of the IRP or RP does not cease with the culmination of CIRP. So the IRP is functus officio only with respect to the CIRP, not for avoidance applications. So even after the CIRP period is over, RP can still take up the avoidance applications. Section 26 also says so. So, and basically, when the resolution applicant submits a resolution plan, he considers these avoidance applications also. And there is an indication in the resolution plan itself that what will be the fate of any property which is recovered out of any avoidance transactions. So this was the case law. ये इसको खत्म कर देते हैं ना, ये वाला, ये कंक्लूजन, ये वाला इसकी जरूरत नहीं, ये डबल हो गया ये। अब ठीक है, ये हो गया टाटा स्टील, वहां कुछ और डाल देंगे अवॉइडेंस एप्लीकेशंस। ये 6 वी हैव ऑलरेडी कवर्ड है ना, ये हमने कवर कर लिया। की फाइंडिंग्स, यस। नाउ नेक्स्ट फ्यूचर। सिंह साहब आप पढ़िए, एसपी सिंह साहब आप पढ़िए। या कोई भी और पढ़ सकता है। सुभाषु जी आप पढ़ लीजिए।
मैं पढ़ लेता हूँ।
यस प्लीज प्लीज, आप पढ़िए अजय जी।
This case law is with regards to Shiv Charan and others versus AA under the PMLA and others and connected petitions. The case of Shiv Charan and others versus adjudicating authority under PMLA and others written petition number this of was adjudicated by the Bombay High Court on March 1, 2024. This case addressed the interplay between the Insolvency Bankruptcy Code and the PMLA, particularly concerning the release of asset attached under PMLA following the approval of the plan under the IBC. So background is that DSK Southern Project Private Limited, the cooperator, was subjected to multiple FIRs in October 17, alleging offences such as cheating and criminal breach of trust. These offences were classified as schedule offences under PMLA. Okay. In March 2018, the ED filed an case and provisionally attached certain asset of the cooperator. The attachment was confirmed by the educating authority under the PMLA in 2019. Subsequently, a corporate CIRP was initiated against the cooperator on December 9, 2021. A plan was submitted by Shiv Charan and others, was approved by the NCLT in Feb 17, 2023. Despite the approval of the plan, the ED did not release the attached property, leading to the legal challenges. So, next page, so.
जस्ट, यस प्लीज।
So issues were here pointing out that whether the NCLT has the jurisdiction to direct the ED to release property attached under the PMLA by invoking Section 32 of A of the IBC, and whether the continuation of attachment under the PMLA post approval of plan under the IBC is valid. The court has findings where that, like the Bombay High Court affirmed that Section 32A of the IBC is non-obstant clause, which means it override conflicting provision in the other law, including the PMLA also. This section provides immunity to the cooperator and asset from the prosecution or attachment or of for offences committed prior to the commencement of CIRP, provided there is a change in management to the person not related to previous management. Okay. The court held that the NCLT has the jurisdiction under Section 60, Subsection 5 of the IBC to direct the release of asset attached under the PMLA once a plan is approved and condition under Section 32 are met. This ensures that objectives of the IBC, which includes the revival of the corporate debtor, are not deflected by parallel proceeding under the statutes. The ED contention that the NCLT overstepped its jurisdiction was rejected. The court emphasized that the NCLT direction were within its purview to ensure the effective implementation of the plan. So the conclusion is that the Bombay High Court decision underscores the primacy of IBC in case of the CRP and clarifies that once a plan is approved and its stipulated conditions are satisfied, the cooperator and its asset are protected from any action under the PMLA. So the ED cannot attach any property once the plan is approved. The judgment reinforced the objectivity of providing a fresh start to the corporate data and ensures the CIRP is not undermined by concurrent proceeding under other laws. So so IBC has override the PMLA Act.
तो ये है इसमें। तो बेसिकली और इसका कंप्लीट जजमेंट भी आपको मिल जाएगा अगर आप ये ना आई हैव गिवन द लिंक ऑल्सो ऑफ इंडियन कानून। तो आप इसको कॉपी पेस्ट करेंगे ना तो आपको पूरे का जजमेंट का लिंक भी मिल जाएगा।
गुप्ता साहब, इसमें अर्लियर जजमेंट में हाई कोर्ट ने ही बोला है तो अलग डिसीजन था, इसमें पीएमएल आईबीसी ओवरराइड द पीएमएल ऐसा करके बोलता है।
Yes, Sudarshan Ji, every case has got different facts. So we have to read the entire case law to understand the entire, basically, say the background of the facts. So based on the background and based on the submissions put forth before the court, they take the decision. So they may take different decisions based upon the arguments put forth before them. So we have to read the case law as it is. So some judgments are favorable, some judgments are favorable to the CD, some judgments are favorable to the RP, some are favorable to IBBA, and accordingly we have to proceed in the court. By court में तो होता ही है ना, all types of judgments are there.
ओके सर, अभी मैं पढ़ रहा था ना उस समय मैं देखा हाई कोर्ट एक जगह में एक डिसीजन दिया, दूसरी जगह में दूसरा
हाँ वो तो
डिसीजन।
है ही। वो तो आपको ऐसा ही पढ़ना है, इस जैसा लिखा है वैसा ही पढ़ना है। Yes, please.
The next case is SE Peter Investment Aircraft Limited versus Union of India. The IBC. This is, I think, fact of the case. Where Go Air had leased 54 aircraft from petitioners, lessors, and due to Go Air default in lease payments, petitioners terminated agreement and applied deregistration of aircraft with DGCA. And DGCA informed petitioner that their application could not be accepted in view of the CIRP order passed by NCLT in respect of the Go Air. In view of the fact that termination of lease agreement was not directly linked to insolvency but stemmed from the breaches prior to the insolvency date, and that insolvency commencement order was passed after lease agreement was terminated, DGCA rejection was inappropriate. Background. Go Air had leased 54, ये तो पढ़ लिया सर, ऊपर ये लिखा हुआ था 54 aircrafts they have leased from some
हाँ हाँ।
सो और उन्होंने नॉन पेमेंट हुआ था उनका। सो जहाँ से केस स्टार्ट हो रहा है वहां से पढ़े क्या?
हाँ हाँ बिल्कुल बिल्कुल।
अब इसमें यदि मान लो वो लोग करंट ड्यूज पे किया नहीं किया कहीं मेंशन नहीं है, सपोज हैड दे पेड करंट ड्यूज, जजमेंट कुड हैव वट एवर डीजीसीए एक्शन इज प्रॉपर।
हम्म।
यस।
वहाँ पे मेंशन नहीं है कि करंट में क्या स्टेटस है।
नहीं, इसमें तो ये कहा ना कि भाई देखो ऐसा है कि ये जो वेदर डीजीसीएच कैन कैंसिल द रजिस्ट्रेशन और नॉट, दिस इज द बेसिक क्वेश्चन बेसिकली।
ओके ओके।
तो ये
नहीं सर,
फाइंडिंग पढ़
उसमें
लीजिए
क्या,
ना। यस।
नहीं उसमें ये था जैसा अभी डीजीसीए ने डिसीजन लिया, तो ये सब एसेंशियल सर्विसेज टाइप उसमें आता है ना सर वो सेक्शन में।
राइट, सेक्शन 14(2). यस।
They cannot.
इसीलिए डीजीसीए एनसीएलटी का बात मान के आगे बढ़ लिया।
हाँ, तो बेसिकली इसमें इशू ये है कि वेदर बिकॉज कैंसिलेशन ऑफ दिस डीजीसीए रजिस्ट्रेशन इट विल इफेक्ट द गोइंग कंसर्न स्टेटस।
But the lease of the aircraft is doesn't fall under the 14 section 2 essential services, I
नहीं
think.
नहीं सर, यदि
License.
करेंट पे कर दिया तो वो क्या लाइसेंस कैंसिल नहीं कर सकते, ये अपना
नहीं नहीं,
सेक्शन
इसमें
बोलता है।
इसमें कह दिया कैंसिल कर सकते हैं।
क्योंकि ये
इसमें क्या
14 टू
कहा?
फॉल नहीं करता सर। निसेसरीज में आपका लैंड लीज वगैरह आ जाएगा, बट दिस वॉन्ट, बिकॉज ये तो एयरक्राफ्ट है, प्रॉपर्टी किसी और का है।
उसने कहा प्रिंसिपल ऑफ ड्यूरा लैक्स सेड लैक्स द लॉ इज हार्श बट इट इज द लॉ, इट वाज अपेंड हार्डशिप टू गो एयर एंड इट्स एम्प्लॉयज कैनॉट ओवरराइड लीगल ऑब्लिगेशंस।
मैं पढ़ लेता हूँ। द हाई कोर्ट
यस
held that
प्लीज।
the termination of the lease predated the insolvency commencement and was based on the contractual breaches, not insolvency. There was no sufficient nexus between the lease termination and insolvency proceedings. The DGCA is statutorily obligated under Section 30, Subsection
Under
7.
Rule 30, sub Rule 7.
Yeah, Rule 30, subsection 7 of the aircraft rules, in line with the Cape Town Convention, to deregister aircraft upon proper application by IDERA holders. The NCL cannot encroach upon the
Encroach.
jurisdiction of High Court or direct statutory body
Statutory
of
body.
DGCA in manner inconsistent with public law. DGCA refusal to process registration was illegal. DGCA was directed to process the deregistration application in accordance with Rule 37. The principle of dura lex said lex, the law, it means the law is harsh, but it is the law, was upheld in this case. Hardship to go air and its employees cannot override legal obligations. ये तो कुछ और इशू था एक्चुअली, इसमें नेसेसिटीज में नहीं था, बिकॉज दे आर सेइंग कि ये पहले से ही इनका ब्रीच हो रहा था,
हाँ,
जो कॉन्ट्रैक्ट
इंसॉल्वेंसी कमेंसमेंट डेट से पहले का इशू चल रहा
पहले ही
था।
ब्रीच हो रहा था।
हाँ, और ये लीज पहले ही टर्मिनेट हो गया था। इट वाज टर्मिनेटेड प्रायर टू द इंसॉल्वेंसी कमेंसमेंट डेट एंड इट वाज बेस्ड ऑन द कॉन्ट्रेक्चुअल ब्रीचेस।
राइट, जो टर्म था, कंडीशन था, वो ब्रीच हो गया था
हाँ
इंसॉल्वेंसी
बिल्कुल
कमेंसमेंट
बिल्कुल।
से पहले ही।
यस, नेक्स्ट केस लो।
दिस इज
सुधर,
द,
अच्छा पढ़ रहे हैं सर।
आप पढ़ लो सर, कोई
आप
दिक्कत।
पढ़ो, कोई भी पढ़ लो, उसमें क्या।
Sundresh Bhatt versus Insolvency and Bankruptcy Board of India, IBC, where liquidator of a company was suspended by a respondent
इसीलिए मैंने
IBBI
क्या
for
किया हुआ है, व्हाट आई हैव डन इज आई हैव गिवन द लिंक आल्सो,
right.
सो फ्रॉम द लिंक यू कैन रीड द एंटायर केस लॉ आल्सो। यस प्लीज।
Okay. Where liquidator of a company was suspended by respondent IBBI for a period of 2 years on the ground that he had he had appointed a firm in which himself was a partner to provide support services and had paid excess fee. Actual motive of liquidator behind appointing said firm was to increase his own fee by circumventing the regulation 4 of liquidation regulation 2016, and therefore impugned order of suspension of liquidator was to be upheld. Facts: the petitioner was appointed as the interim resolution professional IRP of the corporate debtor. Meanwhile, the NCLT directed that the corporate debtor would undergo corporate debtor would undergo
यस प्लीज, आप पढ़ लीजिए।
लिक्विडेशन
हाँ जी।
yes corporate debtor petition was in the, okay. Meanwhile, NCLT directed a corporate debtor would undergo liquidation under Section 33, subsection 2, and the petitioner was to act as a liquidator to discharge duty under Section 35, and later liquidation order was passed against the corporator. Subsequently, the petitioner received a notice of inspection of liquidation assignment of corporate debtor, which was being handled by the petitioner. On 4th April 2022, the petitioner received a draft inspection report under Regulation 6, Sub-Regulation 1 and 2 of IBBI. Legal issue: whether the disciplinary action, a 2-year suspension of the insolvency professional registration of Sandaresh Bhatt by the IBBI was valid, given allegation of conflict of interest, improper valuation practices, and excessive fees paid to related firm. Held that the charge of prescribing non-refundable participation fee on a prospective bidder for participating in the auction process at the time of submission of expression of interest is concerned, the contention of the petitioner is to be accepted in as much as the petitioner has not acted in violation of any express contravention of any regulation or clauses. Material on the record indicates that provision to schedule first sub 1 and 3 of regulation was not in force when the auction took place, and the provision to schedule first 1 and 2 was issued.
Actually, for understanding this case law, we have to see because amendments took place at different points of time. So earlier, there was no stipulation regarding this participation fees. So this liquidator, it prescribed non-refundable participation fees. So the court held, the adjudicating authority held that because this law did not come at that point of time. So this point was not found to be in order, and it says that there is no violation on this ground. There were three actually grounds. So number one, prescribing the non-refundable participation fees. At that point of time, there was no such law or regulation on this point. So IP was found okay on this ground. Second was for appointing unregistered valuers. So there the court held that okay, the valuation report has been given in the name of the firm, but valuation was done by the registered valuer. So he was not found guilty on this account also. Second point was raised that bills have been raised in the name of the firm. So this point was also found immaterial. But the main charge was that
court finding
this fees paid to the MNC. So this was a deliberate attempt. The fourth charge. So 1, 2, 3, they were found minor violations. उसमें कुछ irregularities, minor irregularities. But the fourth charge, yes. So as regards, यहाँ से पढ़ लीजिए सिंह साहब.
Okay.
Regarding the fourth charge.
However, on the fourth charge, the court upheld IBBI findings. Bhatt's appointment of BRAL was deemed a conflict of interest and deliberate attempt to circumvent Regulation 4 of Liquidation Regulation, which caps a liquidator's remuneration. The fees paid to BRAL exceeded what Bhatt was entitled to, and to the terms were vague and unjustified. As regards the last contravention against the petitioner, fees which has been paid to BRAL, which was engaged by the petitioner for providing support services in liquidation process of the corporate debtor, is concerned. The board has found that the petitioner is one of the partner of BRAL, and since the inception of the liquidation process till the quarter period ended in June 2022, the fees payable to BRAL is rupees 2 crore 83 lakh 28,750, whereas fees payable to the petitioner is 2 crore 21 lakhs, and therefore BRAL was paid more fees than the liquidators himself. The board therefore held that any entity engaged to help the liquidator cannot be expected to be entrusted with the responsibility more than that of a liquidator, so as to justify the higher fees to such an entity in comparison to that of liquidator. Therefore, engaging a related entity on vague terms and conditions and paying them fees more than the fees of liquidator is not only unjustified but also mollified, and therefore the petitioner is guilty of contravention of Regulation 7.2 of the Liquidation Regulation, Clause 25A of Code of Conduct under IP regulation.
Actually, this Sundaresh Bhatt, he was a partner in a Big Four. So he appointed the firm as a support service, and the fees paid to the firm, it was more than the fees paid to the liquidator. So they said he is trying to circumvent Regulation 4, which puts a capping on the liquidator's remuneration. So on this charge, he was found guilty.
It means, sir, if it was paid less than liquidator, it is justified.
नहीं, बात देखो ऐसा है ना, इसमें तो क्या है कि भाई यू आर ए पार्टनर, ही वाज अ लिक्विडेटर and he was a partner in a firm also, and he appointed that firm as a independent professional, and that firm was paid more fees than the fees of the liquidator. So he says liquidator is the main person, he is carrying out the liquidation, so anybody cannot get more remuneration than the liquidator. So on this apparently कुछ गलत गड़बड़ लग रही है इस केस में.
My question is that in the same case law, if firm is paid, suppose 2 crore 10 lakhs, that is less than liquidator fees 2.21.
No, in that case, we will have to see the facts of the case. So that will
Okay.
depend upon the facts of the case. So we have to understand the case law as it is.
Okay.
Even then also he is guilty because he is a related party.
Yes.
Yes,
That
yes,
appointed
yes,
related
yes.
party. On that ground also he is guilty.
No,
No,
one
but the
question
legal
again.
point is, Sudarshan Muji, the legal point is that you can appoint an IPE in which you are a partner as a support service provider. So there is no bar on that.
Okay.
So that way there is no bar, but we have to see the related circumstances. Yes, please.
Okay.
So if I directly ask you a question, you are a partner in an IPE, you are appointed as liquidator. So whether you can appoint your partner as an independent, as a professional, the answer is yes, you can.
Support services, yes.
There is a separate provision for that, special provision for that.
In
Yes,
the
please.
instant case, is mentioned that remuneration of the support service provider is more than liquidator fees. Then it was question here, no, sir. If it is less than that, what?
Right. बिल्कुल ठीक
In
है,
that-
बिल्कुल ठीक. Reasonable होना चाहिए ना, it should be reasonable.
Okay.
Yes, please.
Okay. In the court found no reason to interfere with the IBBI disciplinary order on the core charge. However, since the Bhatt had already served 20 of the 24 months of his suspension, the court modified the penalty to the period already undergone. Conclusion: Delhi High Court confirmed that the ethical standard and transparency are paramount in insolvency proceeding. Liquidator cannot use affiliated firm to bypass regulatory caps on their own remuneration.
Next.
Rohit J. Vora versus Insolvency and Bankruptcy Board of India. IBBI is empowered to form a disciplinary committee under Section 220, subsection 1, to consider report from investigating authorities submitted under Section 218, subsection 6. It is permissible to constitute a disciplinary committee consisting of either a single whole-time member or more than one whole-time member of IBBI.
So this question is based on the interpretation. It is based on interpretational issue because it says members. So the section says members. If we see section 220, so section 220 says the board shall constitute a disciplinary committee and provided that the members of the disciplinary committee. So the main argument in this case was that the word used is members. So it is plural. So that means there cannot be a single member disciplinary committee.
Right.
So this was the main issue here.
Okay.
Yes, please.
As the petitioner was appointed an insolvency professional IP by the Insolvency and Bankruptcy Board of India (IBBI) on the basis of investigation report submitted by investigating authority, IBBI through its Deputy General Manager had issued a so-called notice issued to the petitioner under Section 219, calling upon the petitioner to show cause why action as indicated in so-called notice, which included an action of cancellation of the petitioner's registration, should not be taken. The petitioner had responded to so-called notice and On that basis, disciplinary committee comprising of a single whole-time member adjudicated the same and suspended the petitioner's registration for a period of 1 year. The petitioner filed instant writ petition before High Court on the ground that since the so-called notice was adjudicated by a single member of disciplinary committee was contrary to the proviso of section 220, thus the order impugned was vitiated. Next, to consider the question as to whether the disciplinary committee constituted under section 220 can consist of a single whole-time member, it would be necessary to refer the relevant statutory provision chapter 6 of the code pertain to inspection and investigation in the matter relating to any insolvency professional agency or its member. Under the aforesaid provision, the IBBI is empowered to constitute a disciplinary committee for considering an investigation report submitted by the investigating authority. To proceed to subsection 1 of section 220 stipulate that member of the disciplinary committee can only be whole-time members of the IBI. According to the petitioner, since the expression member of the disciplinary committee appearing in the proviso to section 221 make reference to more than one member, the disciplinary committee cannot consist of only a single member. On a plain reading of section 220 subsection 1, it is clear that IBBI is empowered to constitute a disciplinary committee for considering a report of investigating authority that have been submitted under section 218 subsection 6. The proviso to subsection 1 merely require that member of disciplinary committee should be whole-time member of IBBI. The said proviso does not seek to provide the number of members who should constitute disciplinary committee. On the contrary, the object of the proviso is to indicate that it is only the whole-time member of IBBI who can be member of disciplinary committee. In fact, Regulation 2, Regulation 1, C of Regulation 217 state that disciplinary committee means committee consisting of whole-time members. This would therefore indicate that disciplinary committee could consist either of a single whole-time member or more than one whole-time member. Since regulation of 2017 have been framed in exercise of power control,
बस इतना ही काफी है, मतलब मेन देखिए क्रक्स समझ गए आप, है ना
जी।
अब इसका कंक्लूजन देख लेते हैं। क्रक्स तो समझ गए ना, था क्या
जी।
की फाइंडिंग्स पढ़ लीजिए।
Key find. Section 221 of IBC required that disciplinary committee consist of a whole-time member, but it does not specify a minimum number of members. Regulation 21C of IBBI Inspection and Investigation Regulation 2017 define committee as consisting of whole-time members.
Member oblique S.
Yes.
तो member oblique S का मतलब हो गया एक भी हो सकता है, ज्यादा भी,
या दो भी हो सकते हैं, right? Implying it may include one or more members. So the use of plural form of members in section 220 subsection 1 does not exclude the possibility of a single member committee, especially in light of section 13 of General Clauses Act 1897, which state that singular include plural and vice versa, unless the context suggests otherwise. Therefore, there is no repugnancy between the statute and regulation.
बस इतना ही काफी है, मतलब समझ गए बस, और क्या। नेक्स्ट देख लीजिए।
Insolvency and Bankruptcy Board of India versus State Bank of India. The jurisdiction to deal with the validity and legality of regulation framed under IBC is not conformed upon NCLT, and hence NCLT did not have power to declare Regulation 36A of IBI insolvency resolution process for corporate person, Regulation 2016, which had been amended and passed in accordance with the law by IBBI as ultra-virus.
So the question here is, main point is whether NCLT can adjudicate upon such matters. Suppose a regulation has been framed by IBBI, so whether NCLT can deal with the legality or validity of such regulations, because the question of law can be decided by High Court or Supreme Court only, and not by the adjudicating authority. Yes, please.
An application was filed under Section 12, subsection 2 before the NCLT by the respondent number 1, State Bank of India, seeking extension for the completion of corporate CIRP by a further period of 90 days. During the course of hearing application, the NCLT noticed that the expression of interest was floated, however, no resolution plan were filed in response to the same. This splitting of CIRP into inviting expression of interest and then seeking a resolution plan as provided in Regulation 36A became the subject matter of impugned order. The NCLT then held Regulation 36A to be ultra vires of Section 240 subsection 1 on the ground that it was contrary to the speedy disposal of resolution process, despite there being no specific challenge to the said regulation. The petitioner challenged the said impugned order before this court on several grounds, including on the ground that NCLT does not have the jurisdiction and power to decide upon the validity and legality of the regulation. Next, as a perusal of the IBC would show that the Section 3 subsection 1 define board as the Insolvency and Bankruptcy Board of India, established under Section 188 subsection 1. The board is inter alia interested with the function of registration of insolvency professional agency, promotion, development of such agency, supervision of insolvency professional agencies and insolvency professionals, investigation for insolvency professionals, and maintenance and publication of information and data as may be provided in the regulation, conduct the periodic studies, alliances with other statutory authorities, etc. The IBC also specify a mechanism for issuing a regulation after doing a public consultation process. Establishment and constitution of board is stipulated in the section 188 and 189, and power are stipulated in section 196. A perusal of the power and function of the board shows that the overall supervision and function of IBC are to be carried out by the board. Section 196 subsection 2 also vests with the board the power to make model bylaws to be adopted by insolvency professional agencies. The board's power to issue regulation are recognized in section 240. Lastly, section 196 subsection 1 clause U is a broad provision which stipulates that IBBI can perform such other function as may be prescribed. Thus, the IBBI is in effect an authority which is carrying out the larger number of functions related to the implementation of IBC. On the other hand, the adjudicating authority in the present case NCLT is established in terms of section 60. And a perusal of the power of NCLT so that broadly the NCLT is vested with the power of adjudicating any application or proceeding before it, and adjudicating any claim, and also deciding on the question of law or fact arising out of insolvency resolution or liquidation proceeding. Insofar as the present case is concerned, there was no challenge to Regulation 36A of Insolvency and Bankruptcy Board of India, Insolvency Resolution Process for Corporate Person, Regulation 2016, before the NCLT. Therefore, in an application seeking extension of time to complete CIRP process, the NCLT has gone ahead and declared the Regulation 36A as ultra vires.
So this case, it underscores the importance of board and the powers of the board and powers of NCLT. So both are operating in their own fields.
Right.
भाई उससे एक्सटेंशन मांगने गए थे, एक्सटेंशन मांगने के बजाय उन्होंने कह दिया जी 36 से ही अल्ट्रा वायरस है एनसीएलटी को
जी।
तो हाई कोर्ट ने कहा भाई आपके पास इतनी पावर नहीं है, आप अपनी एक्सटेंशन देना दीजिए, नहीं देना मत दीजिए, आप ये मत कहिए अल्ट्रा वायरस है कौन नहीं, हर एक का अपना अपना फील्ड है. बोर्ड ने, सेंट्रल गवर्नमेंट ने बोर्ड को ऑथराइज किया हुआ है और बोर्ड रेगुलेशंस बना रहा है, तो बोर्ड हैज द पावर.
Right.
Yes.
The NCLT does not have jurisdiction to rule on validity or legality of regulation framed under IBC. Its power under section 60 subsection 5 are limited to cases arising out of or in relation to resolution or liquidation proceeding, not the broader legislative or regulatory domain. The power to make regulation under IBC is vested in the IBBI. and these regulations must be placed before Parliament as per Section 241. The Regulation 36A was lawfully enacted and falls within the rule making the power of IBBI. Therefore, the NCLT exceeded its jurisdiction by declaring its ultra vires judgment. The High Court set aside the NCLT order declaring Regulation 36A as ultra vires. It reconfirmed that tribunal like NCLT cannot revive the validity of delegated legislation such as regulation under IBC. Conclusion: the case reaffirm the limited jurisdiction of NCLT and uphold the legitimacy of IBBI Regulation 36A, reinforcing the separation between the adjudication of insolvency cases and regulation making function of IBBI. दोनों distinct functions. Jenny Thankanchan and versus Union of India and others. The case of Jenny Thankanan कौन है सर?
ऐसे छोड़ दीजिए ना, की लीगल इश्यूज पढ़ लीजिए, नाम में कुछ नहीं रखा.
Okay, Vaishji, was adjudicated by the Kerala High Court on November 17, 2023. The petitioner, a sleeping partner in Hawking Technology India LLP, had provided a personal guarantee for a loan of 65.1 lakh obtained by the LLP from IndusInd Bank. Following a default, the bank initiated proceeding under the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002 SARFAESI Act to recover the debts. The key point is the trigger for interim moratorium under Section 96 of IBC. The petitioner contended that upon filing an application under Section 94 of Insolvency and Bankruptcy Code 2016, IBC, an interim moratorium under Section 96 should automatically come into effect, thereby staying SARFAESI proceeding. Overriding effect of IBC over SARFAESI Act, the petitioner argued that IBC by virtue of Section 238 override the other law including SARFAESI Act, and thus the bank's recovery action should be halted. On the interim moratorium court's finding, the court held that for an interim moratorium under 96 of IBC come into effect, the application must be complete, free from defects. In this case, the petitioner's application had only been assigned a diary number and had not been formally registered by NCLT, and due to procedural deficiencies, therefore the interim moratorium had not been triggered. On the overriding effect of the IBC, the court observed that while Section 238 of IBC provides it with the overriding effect, this does not automatically nullify the proceeding under SARFAESI Act, especially when IBC has not been duly admitted. Furthermore, referencing to Supreme Court's decision in the State Bank of India versus Ramakrishnan 2018, the court noted that the moratorium provision under IBC do not extend to personal guarantor of corporate debtor. Conclusion: the Kerala High Court dismissed the writ petition, concluding that interim moratorium under Section 96 of IBC does not come into effect merely upon submission of an application. Application must be complete and formally admitted. The IBC does not automatically override SARFAESI Act in situation where the insolvency application has not been admitted. मतलब application ही खाली फाइल करने से कुछ नहीं होता. SARFAESI फिर SARFAESI का एक्ट सर वैलिड रहेगा unless it is approved by the NCLT.
Right. तो आज की कथा यहीं समाप्त करते हैं.
Yes sir, yes sir. Thank you sir. Good night.
हाँ
सर ये अभी इसमें कुछ चेंजेस किया था सर, इसको डाल देंगे क्या? इसमें चेंज किया था कहीं कहीं, इसको
अभी डाल देता हूँ.
यस यस यस, अपडेटेड हो जाएगा सर.
हाँ हाँ बिल्कुल बिल्कुल.
यस सर.
ओके सर, गुड नाइट.
गुड नाइट जी, गुड नाइट. तो अभी मंडे को बाकी कवर कर लेंगे इसमें, है ना?
यस यस सर.
मंडे को एनसीईआरटी और अब इसको अगर आप पढ़ के आओगे ना खुद तो और अच्छा रहेगा.
अच्छा सर, वो सर एक वो आपने डाला है इस पे, वो कोर्स कुछ ऑनलाइन टेस्ट वगैरह कराते हैं, 14,000 समथिंग कुछ फीस है उसमें, 2-3 लोग. वो सर बेनिफिशियल है? टाइम नहीं मिल पाता उससे बड़ा. और उसका सेशन क्या होगा, कब से स्टार्ट होगा वो?
वो 8 तारीख से स्टार्ट हो रहा।
8 जुलाई से।
अरे वो यही पिक्चर है जो आप देख रहे हो।
अच्छा, यही पिक्चर। तो उसको ज्वाइन करने की जरूरत नहीं सर।
भाई देखो ये पिक्चर खत्म हो जाएगी मंडे को,
ओके
ट्यूसडे से अगली पिक्चर लग रही है।
ओके ओके। सर कोई बेनिफिशियल होगा तो सर इसी बहाने थोड़ा पढ़ लेंगे हम लोग, हैं?
भाई अगर वो आपकी मर्जी है, आप क्या करना चाहते हो।